Welcome to the Injury Lawyer Podcast, a podcast that discusses all types of injuries caused by all types of negligence. Join attorney Steve Heisler, the injury lawyer, and other experts as they provide valuable insight into your legal rights and help keep you informed. Now your host, Steve Heisler.
Hello, it's Steve Heisler, and welcome to the Injury Lawyer Podcast. We're a podcast that discusses all types of injuries for all types of negligence. And I want to welcome you back. I hope you enjoyed our first episode. We're on our second episode now. Want to say hi to Russ. Russ, how you doing, brother?
How are you, Steve?
I'm hanging in there. My daughter she's getting married in September, so we had a bridal shower.
Congratulations.
Yeah, we had the bridal shower over the weekend. The problem was that it was at our house. So I'm in physical therapy now I had to carry all the tables from the garage to the deck. And, she had like 40 people. So it's like 7 tables that were extremely heavy. So it was an ordeal. And, just basically I was caterer, host, parent, everything. So, Still getting over that.
Is this the reason why I'm hearing rumors about you having some kind of device? I think Michael Jackson had this device. I don't know.
You're talking about the hyperbaric chamber.
Yeah. Is it a device? Is it a piece of furniture? What's happening here?
I purchased a hyperbaric chamber. My dad had to go into a hyperbaric chamber because of scar tissue that he had from radiation for cancer like 30 years ago. And I noticed he's 90 years old. I noticed when he came out, he was even sharper than he was before he went in. He had like 60 sessions. So I got really intrigued with hyperbaric oxygen therapy. And I've decided to purchase one a couple months ago. And
very nice.
You can tell, you can see that I'm as sharp as a tack. So as a result of my hyperbaric usage.
So when you're 90, you'll look like you're 68.
Well, I look like I'm 68 now. So,
No.
Yeah. Well,
all right.
Yeah,
so,
we'll see what happens.
Remind me, is this the introductory episode for your show?
No, this is not our introductory episode.
This is episode 1.
No, this is episode 2.
Episode 2.
I'm so glad that we brought you on as producer and engineer. I'm Steve, the injury lawyer.
Steve, that's right.
Yeah,
Steve with the hyperbaric chamber.
Correct.
I'm not here to keep stats on what episode we're on. I'm just here to have a little bit of fun and be enlightened by everything you have to say.
Well, I think you might find today's topic to be a little more enlightening than our last one. The topic today is actually, burned by hot food. Do I have a negligence case against the restaurant? Now, of course, you're probably saying, all right, Steve, of all the topics, why, how did you choose this one? So let me ask you this. Are you familiar with the McDonald's case back in the 1990s of
hot coffee?
Hot coffee.
Who's not?
Yeah, I think there was like a Netflix episode or series about it, or there was some documentary about that particular whole
huge.
Incident.
That incident was huge.
Yeah. I think what was lost on, I guess, for people that just kind of heard, you can spill coffee on yourself and get $1 million. Well, the lady actually had to get surgery and had to get skin replaced. So it was a pretty significant 3rd-degree burn, and it was the jury that awarded the money. So it wasn't as if the money just fell out of the sky. The jury, the great thing about this country is that if we have any type of quip or a quibble with any type of company or person where negligence is involved, you have the right to take it in front of a jury of your peers, is what she did. And the jury came back and actually awarded her $220,000 in compensatory damages. And compensatory damages are like pain and suffering, medical bills, any lost wages she might have had. But they had to they reduced it by 20% because they thought she was 20% at fault because she had the coffee in between her legs because she went through the drive-through, and I guess she spilled it, and it spilled on her. It spilled on her thigh.
How many cars had cup holders then?
That is a really good point. I don't think a lot. I think the cup holders were was in between your legs. That was your cup holder. That's kind of a dicey thing.
Correct me if
that
I'm
might have
wrong.
been the impetus for cup holders, that particular incident. Yeah.
Listen, in America, we have to have 16 cup holders in our
absolutely.
Cars. But correct me if I'm wrong. Is that the case? Which brought us to where now every just about to-go cup at a restaurant has a warning on it about contents may be extremely hot?
That might be the case. I have to say that I don't drink coffee. I don't really drink hot drinks, so I don't really pay attention to it. The reason I even brought up the coffee case is because I read recently that a little girl, 4 years old, an autistic girl, who was in the back seat of her mother's car when she went through the drive-through at McDonald's. McDonald's again. I don't know. So she actually ordered. The mother ordered a Happy Meal, and as a result of her ordering the Happy Meal, she got a Happy Meal. She handed it back to her kids in the back seat, and the daughter opened up the Happy Meal. The chicken McNugget that is in the Happy Meal fell on her thigh, and she ended up getting second-degree burns.
Oh.
Yeah. So as a result of that, as a result of that, she made a claim against McDonald's and the franchisee. The interesting thing was that, ordinarily you pick up a chicken McNugget and you don't burn your hand or but according to the attorney for the little girl in Fort Lauderdale, that chicken McNugget was at a temperature of 200 degrees.
Wow.
And so, you touch anything at 200 degrees and you're going to get a burn. And hers, luckily, was a second-degree burn, which is nothing, to scoff at. But
of course,
still, it could have been a lot worse. But still, it was enough that she had some serious injuries for a 4-year-old girl with a second-degree burn. So, I wanted then to talk to you out there, every listener, and discuss, burned or scalded by a hot liquid or hot food. Do you have a negligence case against the restaurant or the proprietor, whoever served it? So obviously, it seems that McDonald's has a problem with their thermometers because they can't seem to get it right. I have some thoughts about, and you might have some thoughts, Russ, that you can kind of step in and ask. But what I wanted to first talk to you about is, what do you need as far as elements, or what criteria or what factors do you need to be able to bring a case against a fast food restaurant or a coffee shop for negligence, whether it be from, now we're talking today about being served scalding hot food, but it could also involve slipping and falling on the premises. Or
let me, if I can just jump in here, because it's interesting you say that, because just over my phone I got a notification, and the headline is, it's got the Burger King logo, and it's from a news source, and it says, "Major payday, Burger King will make huge payout to customer who slipped and fell." slipped and fell.
Was that the 18 million? Was that the 18 million?
I didn't even go into it. I'm not caught up on my phone yet. But it's just interesting that today, the day of this recording, is when you're discussing this.
Yeah. So that's actually it's pretty timely. Bottom line is that when you're in a restaurant, and that's actually the first factor. So there's 5 factors in order to have a legitimate negligence case so that you can go after a fast food restaurant. And I don't like the word go after, but you have the right to make a claim against a fast food restaurant or any kind of establishment that serves food or serves drinks. So the first thing you need is you need to actually establish a duty. All right. So basically you have to show that establishment has a duty to keep you safe. And the fact that you're going in there to spend money to purchase a Happy Meal, to purchase whatever, hot coffee or whatever, they have a duty to make sure that that food or that coffee or that drink is safe. And not only from excessive heat, but also from bacteria. Or I have a case right now where a guy went into McDonald's and actually there was a cleaning solution in his drink. And again, I don't want to get into it, but so just like anybody else, McDonald's, Burger King, Starbucks, whatever, they all have an obligation to make sure that they treat you with reasonable care and that they keep you safe when you walk in there, when you walk out, and when you consume their product. And by the way, I just also wanted to get back to the little girl in Fort Lauderdale. The jury actually found that the franchisee was negligent or they were liable for negligence and failure to warn customers of the risk of hot food. So obviously, you have to, like you said, if it says on a coffee cup that you need to wait 5 minutes before you drink it because it might be excessively hot at the time that you're getting it, then obviously they're probably doing what they need to do. But there was no evidence that I know of that there was anything that said don't touch the chicken McNugget for 5 minutes or 10 minutes. And it was at the drive-through. So, it's probably hot off, hot out of the fryer or the oven. I don't even know how they make those things. And, before you know it, it's in the hands or on the thigh of the consumer because, kids eat Happy Meals. But they found, and they also found McDonald's USA liable for failing to provide instructions for safe handling of the food. All right. So apparently there's some kind of problem with communication between McDonald's, corporate McDonald's, and one of the franchisees, or maybe it was just a franchisee's negligence for not following those instructions. But either way, that's what the jury found. So again, the purpose today is to let you know what you need to establish to be able to bring a negligence case against an establishment that serves hot food and hot drinks. So we said, number one, duty of care. And that means, as I just said, that they have to, they owe you a duty. You have to show that they owed you a duty. And if you paid for your meal, there's a duty there. All right. Or even if, the fact that you were in the establishment and they're there for the purpose of selling food, selling drinks, they owe you a duty to keep you safe when you're in their establishment. All right. Number 2 is breach of duty. All right. So obviously we established that you have to establish that there is a duty. Then you have to establish that that duty was breached. And there's a breach of duty when they don't keep you safe or they don't serve you food that is not going to rip off the skin from your leg or your hand, or God forbid if she had put it in her mouth. So yes, there's a breach of duty. So as long as they had that duty, and somebody was injured because of their failure to warn you of the hot nugget or chicken McNugget or the hot coffee. Okay. Number 3, causation. And this is you might, before I went to law school, I probably would not have known what causation meant. So I'm going to explain it to you. So causation is where you have to show that their breach, that their failure to warn you of the hazard of of that hot coffee, their failure to warn you of that caused you to suffer some damage. All right, so it wasn't anything else. So, for instance, if the mother, had actually given her the chicken McNugget and it fell on her thigh and her thigh was burned, but maybe the day before she had burned her thigh, the same area of the thigh, on a furnace or something like that, then the McDonald's would probably say, well, how do we know that that was the cause of her second-degree burns? How do we know that she didn't have pre-existing second-degree burns and that McNugget wasn't the cause of it? And that's not what really caused her to have the burn. So you have to show that that McNugget caused her to have that burn. Okay, so that's number 3. That's the third factor you have to show. Number 4 is foreseeability. And all that means really is that you have to show that the fast food establishment or the food establishment, it was foreseeable to them that if they served to you a scalding chicken McNugget or scalding coffee or scalding food, and that if that in and of itself, it's foreseeable that if you're not warned that it's hot and you need to be aware of that it's foreseeable that it could cause an injury. And that's what happened. It's foreseeable. So, it's usually not as hard to prove element 4. So that's, it's foreseeable that if you're negligent, that your negligence is going to potentially cause damage to somebody. And of course, number 5, and this is really, really important, you have to prove that as a result of the negligence of McDonald's or Burger King or Starbucks, that your damages, your injuries were caused by the negligence of Burger King or McDonald's or Starbucks or Chick-fil-A or whatever. Okay? And by that, I mean, not so much that they were caused, but also that you actually were injured at all. I've had lots of cases where people have had car accidents, they've slipped and they've fallen, or they had all different types of, they've had incidents where they believe that somebody else was negligent, but they weren't injured. And they called and they said, well, I want to make a claim against this person because they could have killed me. Yeah, they hit my car. Yeah, they left a banana peel on the floor and I slipped and fell. I wasn't injured, but I still want to make a claim because they could have killed me. I could have broken my leg. All right, well, I got a news flash for you. Unfortunately, in order to have a case for negligence and make an injury claim for negligence, you have to be injured. Not, I really wasn't injured, but I just feel that they should be punished for bad conduct on their point. And I understand, I get it. I think that that's very, very reasonable to want to do that. However, without an injury, you're not entitled to a recovery. Now, and I don't want to get too far off what I'm talking about, but I will tell you this. A lot of times, for instance, I've had people that have opened up, they've been at McDonald's or Burger King, they open up and they find a bug in their hamburger, or they find, something in their food or whatever. They find some kind of an insect. or I've had people find who had metal in there, if they found a nail, but they weren't injured. And it's really hard to prove they were emotionally injured. But I always tell them, well, you might want to call over to McDonald's or Burger King and tell them what happened, and they might decide to give you, a gift certificate or something like that.
That brings me to a great example, because less than a week ago I was at a deli and I had some eggs, and in the eggs was like a curly piece of metal, as if maybe from a Brillo pad or some kind of cleaning pad. So
scrumptious.
I did take a bite, and I felt it. I took it out and I put it down there, and I'm like, oh my gosh, this could be some kind of huge lawsuit. But you're right, I was not injured. I let the server know. She felt horrible. The cook felt horrible, and she said, let me make you another omelet to go, this and that. And I said, no. I said, no harm, no foul, I'm fine. And she says, no, you've got to let me give you something. I said, all right, you know what, black and white cookie, the big cookie with the vanilla and chocolate icing on it.
Wow.
And you know what, she gave me which is probably like a $3 or $4 cookie. But really? I was happy. I was pleased, and I didn't want to cause any trouble because I didn't have any kind of injury from that. You
didn't go to the manager and ask the manager for a share of the equity in the restaurant?
No.
All right. Now I think you did exactly what. That's what it's probably what I would do. And look, I mean, things happen, and sometimes things appear in food, and it can definitely, some people it affects differently. For me, I'd be like, unless I found like a rodent or something like that, I probably would just like take the part that didn't have the the Brillo pad or whatever.
In the case of a rodent, I would ask for a new meal. But I'll
you'd
tell
ask,
you this.
You'd ask for 2 cookies or 3 cookies. Give me a whole bag of cookies. Yeah.
If I swallowed the metal and it cut my throat and I was, coughing up blood, then
that's a
that would be a different story altogether.
Yeah.
Altogether.
Right. So, that's a really good point, Russ. Again, so you have to show that your injuries are real. Now, look, if you swallowed some Brillo pad and you had got caught in your larynx or something like that, or you couldn't, breathe or whatever, it's a different story. I have a case where somebody went to a Mexican restaurant and a chicken bone got lodged into her throat, and she had some real problems with that, and so she obviously had an injury. So I think you get my point. So if you have those 5 factors, and again, a lot of times you're not going to go down everything before you talk to an attorney. If you think you got a case, talk to an attorney, and an attorney will let you know if you have a case or not. And the bottom line is that if there's a case, they're going to let you know, and they're going to make sure that all those factors are sufficiently there before they pursue it. And if they think that there's not a case after further review, they'll let you know. I will tell you one thing: if you work at like a Chick-fil-A or whatever, and you get burned by a hot coffee or by the food, you're not a customer, but you're a worker, you can make a workers' compensation claim. So that's just for our food service workers out there who might say, well, what about me? I work there and I got, a scar on my arm when my arm accidentally hit the grill or something like that. So, but that's another topic for another day. All right. I do want to talk also quickly about, since we talked about, we're talking about the burns that the little girl received. I will tell you this: 1st degree burns are basically mild pain. There's, if you have something like a chicken McNugget or anything that, or hot liquid, it's a 1st degree burn. If it's reddish, mild, you have some mild pain and it heals up without any scarring, I would tell you that that's probably not a case that most attorneys would take, because it clears up pretty quickly. It's not really that severe, and there's probably cost the attorney more money to pursue the case than what you would get back. In a situation like that, if it's a first degree burn and it's not that serious, I would just contact the establishment and say, hey, this happened, and can I get what was that, Russ? A black and white cookie? What was that?
A black and white cookie. Now I have a question for you. In
Sure.
the case of this chicken McNugget in Fort Lauderdale, I believe you said the little girl in the backseat was, I think she was autistic?
Yes.
Okay, so in that case, what about somebody like that might have a lot of I don't know the case intimately, so I don't know if they're also making a claim for, for an exacerbation of, of her autistic issues. But yeah, it's a really good point. So that's really something you need to think about too. There can be emotional issues if you have a burn, and especially if I don't want to say she's special needs, but in where you have special needs individuals, you take the plaintiff, you take the customer, you take the person who was injured as they come, and if they've got pre-existing emotional issues and this made it worse, McDonald's or the establishment, the defendant, is on the hook for it. So that's thanks for bringing that up. All right, now, so first degree, not really that serious case, not really worth much. Second degree, now that's what the little girl sustained in Florida. That's where you have damage to the dermis, and the dermis is where is the middle layer of your skin. So the further down that burn goes, the more significant it is, and the higher the degree of the burn. So that's a second degree burn, and usually with second degree burns, your nerve endings are still intact, but it's super painful. It can take up to a month to get better. It blisters. It will blister before it fully heals. So, getting back to what you said, Russ, in her situation, it's not the worst kind of burn you can get, but for a child, it's pretty significant. And I think there is definitely an emotional component to it. And I would definitely make that part of, if I represented her, I definitely would make, the fact that she's autistic and she's 4. So she's 4, and anything that happens at 4, any type of burn, you're not physically at your mature and at your maturity, and your body still is growing, and and emotionally you're not at your mature level. So it's even more debilitating, I think, for somebody that age. So it's a good point. But anyway, on second degree burns, yes, we take those cases. I would take it. A lot of other firms would take it, and but it's not. Those cases, they heal up in a month. The damages are not as high as if it's third degree or higher. And when you get to third degree, that's when it's not life endangering, but it's significant, can leave some pretty bad scarring. You see a lot of third degree burns and house fires, and scalding cases. I had a case with a little girl that, unbeknownst to her babysitter, she was put into a scalding tub, and but she screamed so loud when her foot was in there before her whole body was in there. But it was a third degree scald, and she's got permanent scarring for life. She's just her foot is disfigured. So a third degree burn is nothing to play with. It penetrates deeply into the skin. Okay. Fourth degree, it penetrates the fat. Fifth degree, it penetrates through muscle. Sixth degree is usually fatal. Bottom line, anything over second degree is something that an attorney would normally take. We would take it at my office. Also, what you need to know is that anything over 165 degrees is too hot. Okay. And so maybe when you're out at the fast food restaurant, I mean, I'm Mr. Healthy. I don't eat at fast food restaurants. I used to. I grew up, I
I should have bought stock in McDonald's as early as 5 or 6 because I lived in McDonald's until about age 30. But if you do go to fast food restaurants, that this is something, or and not even, you could go to I could go to a vegan restaurant or go to a healthy restaurant, and if they heat something up and it's over 165 degrees and they don't warn you that you better watch out, this is too hot, then they could, they're liable. So you need to know that. I'm trying to read my scribble here. They have to, customers should be warned when there's a possible hazard. Okay.
So how many times are you at a restaurant and they're bringing you, your meal, and the staff, the server will say hot plate, and you'll reach out to grab it and put it on, and they're like, no, the plate is hot. So they're trained. Yeah. Those are the ones that are trained properly.
Yeah, they're right. And if they don't, then they're liable. I mean, it's just the standard of care. It's what they're responsible for doing. So, so do you have any, Russ, any other questions from, about this? I mean, it's a pretty interesting. So what I'm going to try to do on this podcast, because there's, I'll admit we're a litigious society. There's always litigation going on. So I talked about last time about, a lady that, I believe, her baby died, or she was severely injured from a placental abruption. So, and I talked about that case. So, so I'm usually going to talk about a case and then go into it, go into the topic and just give you some advice about, what you need, or what has to be there for you to be able to make a negligence claim. In the other case, it was medical malpractice, and we're going to cover products liability and all different types of, defective products. Just all different types of injuries and negligence. So any, before I sign off, any other words of wisdom, Mr. Russ?
No, the only other question I have is, after we wrap up this episode, are you going to go into your hyperbolic chamber?
So I go in the morning. So I get up like at 6 a.m. And then before I do anything, I usually don't get to sleep to about 11. I like to get 8 hours of sleep. So I just go right down to the chamber, and then I get in the chamber for an hour and a half.
Ooh.
And I sleep for about an hour of it.
Wow.
So I get in there and I sleep, and it's like, I feel like I'm in my own little cocoon and nobody can interrupt me. I don't turn on my cell phone before I even get in there, because I just want to be, And the one advantage, and you'll have to let me know if you think my cognitive abilities are declining, I'll need to get a refund from Respiro 270, who's the manufacturer of my So
and this is no endorsement.
Oh no! I have no Respiro. That's the model I use, and look, if they want to sponsor the podcast, that's great. But I don't know if anyone else listening to the podcast.
Just me.
I will tell you. I will tell you though that one thing about hyperbaric chambers, whenever I go in a mild chamber, but for people with burns, look at Jay Leno, whose face was burned from that. I guess he was playing around in his car in his, by his engine, and it blew up. They put him in a hyperbaric chamber, and he made a really fast recovery, and those scars or those blisters or whatever, they went away pretty quickly.
Yeah, I said hyperbolic. It's hyperbaric. Yeah,
it's hyperbaric, and my dad calls it hyperbolic. But he's 90, Russ. You're like 30.
But he looks 80.
He does after that. That's correct. So, all right. Well, listen, if you guys have any questions or problems at any time, you can always call me at 410-625-4878. Now, you know me, I'm always like a last minute guy. And so we're going to have, you can, if you want to, and the best way also to get me is just email me at sheisler@injurylawyermd.com. And I know that's a little, hard to, it is. I think it's going to be a lot easier because I'm in the process of getting my new email address, which will be steve@theinjurylawyerpodcast.com. But for right now, sheisler@injurylawyermd.com. And if you've suffered a scald or a burn due to hot food or a hot drink at a restaurant or any food facility or establishment, or in general, we handle all different types of burns and scalding cases. Contact me at that number, 410-625-4878, or email me at sheisler@injurylawyerm as in Mary, D as in dog.com. We are based out of Baltimore, but I handle cases throughout the country. I also, what I do is I affiliate with co-counsel in other states. And if it's a case that we're going to take, I usually will get admitted into that state for that case, or work with co-counsel to work together with them in that state to take the case. Anyway, Russ, it's great. You have a good one. Good luck to your Dodgers. I think they won. They played Atlanta last night. Did they win?
They tied it, and then they lost. The Braves walked off.
Oh, that's right. Riley hit one above the chop house. Yeah, Matt Riley. No, Olsen. Olsen was,
great ballpark.
Well, the Orioles,
by the way, in Atlanta, great ballpark.
Yeah, I've been there. It's great. Anybody, I don't know if you're a sports fan or not, but we went there. I went with my kids and we loved it. The Orioles beat the Yankees, so that always makes my day, makes me sleep well. I walk with a little spark in my step because just a Yankee hater. But I do love New York people. My parents are from New York, and I love New York.
I was born in Queens, so I hear you.
My mother was born in Brooklyn, and my father was born on the Lower East Side of Manhattan. So I got New York in my blood, but I was born in Baltimore, man. So I'm an Orioles and a Ravens fan.
All good.
But anyway, hey, we will see you next week with another episode. If you have any questions or comments, whatever, love to hear it. All right. Talk to you soon. Have a great day. Have a great week. And I will be seeing you soon. Bye-bye.
Thanks for listening to the Injury Lawyer Podcast. Connect with us at theinjurylawyerpodcast.com and sign up for our newsletter. If you enjoyed today's episode, we would love for you to follow, rate, and review us on Apple Podcasts. To find out more or get help anytime, visit theinjurylawyermd.com or call 855-396-2637. That's 855-396-2637.